welcome to the privacy policy workshop. The size of the print for what I'm going to go through, which is a Word doc, I'm just sort of walking through this outline. It's like a workshop. So you might either want to move up here, depending on your eyesight, to get a little closer, or get closer to the screens, because I'm not going to be able to make type much larger than that, so I apologize. All right, so privacy policy workshop. All of you have a privacy policy. In fact, you may have more than one privacy policy. I'm not sure. You may have one for everything. You may have one for California. You may have one for GDPR. You may have one for employees. Anyway, although it does seem that most businesses have just, one privacy policy that they post on their website. All right, so we'll begin with sort of the obvious question, right? Well, why do you need a privacy policy, right? Why is everybody doing this, right? So back in 2004, California passed the Online Privacy Protection Act. It was the first law in the country that required businesses to post at least an online privacy policy about what was going on the website. And I emphasize that because privacy policies today go beyond what's collected at the website. But at least back then, whatever that was, 20 years ago, 19 years ago, that was the issue. And so California passed a statute. Basically, if a California resident or business was, navigating to your web page, regardless of where you are in the country or the world, there's no threshold of, I'm this big, 25 million or whatever. It was just anybody who had a website was required by California law to post this privacy policy on their website. So it applies to any person or entity that owns or operates a commercial website or online service that, quote, collects and maintains person identifiable information from a consumer residing in California who uses or visits that website. So even if it's not someone who your customer, that individual, they're just navigating, they're just browsing around, right? They're surfing, and they're from California. This law required that you develop and post your website privacy policy. Okay, and then what did it say about this? How you were going to post it, right? Well, it said you must conspicuously post it, right? You can't sort of bury it, somewhere in your terms and conditions or on some other page, which is why we all see the, down in the footer, right, on almost every homepage, you see the privacy link, right, the hot link. That's why it's there. Maybe you also see some other things there, terms of use or other items, but there's at least that privacy link. So the law requires that you put the privacy policy on the website's homepage. Well, nobody does that because the landing page, you don't want it to be a privacy policy it's for marketing merchant purposes, right? So, or you can put the link, that's number 2, which is the privacy, in the footer. And there's requirements that you can't bury it. It's got to be at least as big as the print that's down there, and you can't be you got to make sure people can see it, right, conspicuously. You can't hide it. A type font or color that contrasts with the surrounding text. A lot of times you see it on black background with some, white or yellow text or something to make sure you can see it. All right. And then it required certain things to be in the privacy policy, right? A list of the categories of personally identifiable information that website, the operator, collects, right? And I note here the term categories. You don't need to say every piece, like, it's an IP address or it's a, whatever it is, an email address or whatever. But the categories, and California is into the category concept of that PII. a list of the categories of third parties whom you may share that. And here, that definition of share was probably what we would think of as share. A description, number 3 here, of the process, if any, right, so this is 2004, right, if any, by which you allow that person to review and request changes to what you've collected, right? So contrast that with these comprehensive privacy statutes that I was talking about earlier, right, the California one now and the Vermont and Virginia and those, where there is an absolute right for the individual to not only know what's there, but to maybe not only correct it, but maybe even to have it deleted. But again, this is back 2004, there was no requirement. And I also emphasize that because if you're not subject to the California, to the CPRA, or the new Vermont, the new Virginia, or the Colorado, or the Utah, or the Connecticut statute, really this statute, and there are some others in the country, is what's driving you to post a privacy policy. At least until the FTC, they're in this rulemaking mode now, right? I mean, they may come out and say some things, but right now, there's no federal standard as to what should be in your privacy policy. There's this California statute, and there's some duplicates of that in other states now. But beyond these requirements is probably, you'd have to ask your counsel, depending on where you're doing business, which states. But this is sort of the baseline requirement, assuming you have someone from California who's hitting your website every now and then, right? So that's number 3. I hope you can read this, right. Number 4, a description of the process by which you notify consumers of changes. So you have to say, we update our privacy policy periodically and we'll post it here, and you need to come back to the website and check the privacy policy. Sometimes if you really want to be conservative, you'll put a notice on your homepage saying, our privacy policy has been updated. That's a good thing to do, right? There's nothing wrong with it. Our privacy policy has been updated. Maybe you're tracking them so you know the last time they were there, and you can say since you were last here, or maybe you just do it for, some period of time, hoping you eventually catch everybody who's coming to your website and let them affirmatively point it out to them, right? All right, and then you have to give the effective date of your privacy policy, right? So if you update it. And then in 2013, the whole do not track issue sort of surfaced, and many of you may be or may not be familiar with this, but in all your browsers, regardless of which browser you use, there is a do not track feature that if you knew it was there, you might have turned it on. But in many ways, it doesn't do anything because the browser is not really in control of that. The idea was this was a way for you to flag to wherever you were going, wherever you were surfing, navigating on the internet, to say, hey, I don't want to be tracked. If I go to your website, don't track me. It was a messaging, but no controls, no logic, no software, right? Nothing like that. And so then, and it wasn't just California, but California was the lead to say, hey, you need to tell the individual, how do you respond to do not track? Because maybe everybody thinks, oh, I found the do not track, I turned it on, and now nobody's tracking me, which is not the case, right? That's not the case. So you have to tell, advise, notify in your privacy policy that, you don't respond to it. You don't acknowledge it. You can say things like that. We do not acknowledge, we do not respond to do not track. So if you turn it on, don't expect us to do anything. I mean, that's basically what you're saying, maybe not quite that blunt. And whether you allow third parties to engage, behavioral targeted advertising, right? Because all, the Google products, the Pixel, Facebook Pixel, the LinkedIn, I forget the name of the LinkedIn, but these are all products that you can embed in your website and maybe, with Facebook or whatever, so that when someone is moving from Facebook to LinkedIn to your website, it's all being tracked. You know where the user was and where the user's going, right? All maybe to develop this behavioral targeted, advertising is the goal at the end of the day. So you're supposed to say, if you allow third parties, and I'm not pushing Google or Facebook or LinkedIn, but everybody knows those, right? Instagram, whatever, to engage in that cross-site tracking right across. Okay. So then, the GDPR, the CCPA, CPRA, and remember, the CPRA is just a huge amendment to the CCPA. Virginia, Colorado, Utah, Connecticut require that you post a privacy policy. But as I said before, while the California was focused on collection, these comprehensive privacy are not so limited. Think about all the PII that you collect in email, in texting, on paper. You have all sorts of interfaces to, maybe you're using Salesforce and your clients are coming right into something. There's all sorts of ways where you're letting your clients, for customer service purposes, right, integrate, access, giving them some sort of user experience into your apps, right? And so when you're doing, that, right, you're collecting it there, right? It's not just on the website, right? And it could be paper. I mean, to the GDPR and the CPRA, it's just, is it personal data? That's the only question. And if it is, it is. So what are you saying in your privacy policy about all of that? That's a huge data set. So that data set is probably larger than maybe you've been thinking. And the GDPR and the CPRA, or at least the California since January 1, apply to employee and job applicants. So what are you doing there? Do you know that your employees have a right, at least California or European, to look at your privacy policy that you posted and think, oh, this is the privacy policy for me as an employee? Probably you've gotten together with your labor and employment lawyers and your HR staff and put together some kind of a privacy policy or whatever, right? It's probably in your handbook. And that probably varies greatly from what you're saying in your privacy policy on your website. So you might need to exclude, if California or the GDPR apply to you, right? You might need to think about, well, I need to say this does not apply to employees or job applicants. This is not anyway, so you get the idea. So that's something to think about. Okay. Individuals versus, and I'll just say companies, even if they're customers, right? So, and this in some ways relates to the business to business, the business to consumer concept, if you were there for my talk this morning. It is related to that, but it's not total overlap. What's my point? Privacy policies are about individuals or household, okay? And the GDPR, it's a data subject, which could be an individual or at least someone that you can, even if you don't know who the person is yet, you're collecting data about that, whatever that is, that may eventually you be able to associate with an individual. And so that's what it's about. It's not, if you're a business to business, that's all you do no individual business, right, with consumers. Why are you, think about what you're saying in your privacy policy. It is focused on individuals. And I see a lot of privacy policies where they're just thinking about their customers, which are corporations, LLCs, whatever, right? That's not the focus of the privacy policy. The only reason you're doing this is because the law, requires you to do it. And the whole purpose is to present, my personal data, your personal data, right? It's not about protecting your customer who's this company that you're selling products to or buying products from. It's not about protecting their business data. That's not the focus of the privacy policy. And we see that because it's a natural thing to do, to sort of confuse confidentiality with privacy. I mean, they seem to be the same thing because you want to keep, the privacy policy is all about keeping things confidential and of course protected, but it's not confidentiality. And a lot of privacy policies that I've seen, they talk about, we're going to keep your information, confidential. Why are you even talking about that, right? Especially if it's your customers who are businesses or your suppliers, right? I mean, that's not the focus of the privacy policy. So sort of reorient your thought to this is just about individuals or households, California. And then remember, sort of point E here, right, that the GDPR and the CPRA consider that the information obtained in that business-to-business setting, name, email address, phone number, you're there. Okay. Okay. Many websites have some terms and conditions. They're called terms of use, terms of service, right? Terms and conditions, something on the website. And when we think about, a lot of the SaaS products, right? All the social media, hosted applications, whether in the consumer space or the business space, you're only setting up your account online, right? I mean, how many accounts have you set up online, over the last, 10 years? And so if you're setting up an account online, right, well, there's a contract, right? There are terms and conditions that are being bargained for, supposed to be bargained for anyway, in that setting. And that's not the privacy policy, right? The privacy policy is really a unique animal. And it's best, or I would suggest not to confuse the two. And what I see in a lot of privacy policies is in the privacy policy somewhere it says, and you agree to our terms and conditions. And it's like, well, why are you doing that? I mean, that's not what the privacy policy is about, especially when it's about some business commerce and you're not even doing business with an individual. But regardless, why is that in your privacy policy? Now, the converse is a different issue. In your terms of service or whatever you're putting out there, terms of use, maybe you do want a commitment from that person that they're going to comply with the privacy policy. But again, the privacy policy is applying to an individual, and the terms of use may not be. The terms of use may be applying to an entity, right? And maybe this seems too contractual or legal, but it's really a focus. If you're not focused on why you have a privacy policy and who's it about, you're sort of going to get off track and maybe say some things that you don't. The privacy policy is enforceable, and you might not want to say more than you need to say, right, from one perspective. Yep.
What's the loss mitigation factor of saying, okay, well, we don't have it, so what's the fee, fine, what's the penalty?
What's the loss for what?
Of saying that we either we haven't met all these conditions for the CPRA, or well, we're not collecting the data, or we are collecting the data, we're not giving you a right to opt out. Is the penalty so high that it outweighs the risk of saying, well, we've done this?
Yeah, great question. So the CP, it depends on which statute we're talking about, right? But let's just talk about the CPRA, right? So the California authorities, we'll just say that, right? The Attorney General, maybe the new agency, has enforcement authority, and they can fine you. And there's like a $2,500 civil bond, but it's like for each violation. So it could get, yeah, it could rack up. And whether that's really what they want, what they really want to do is get everybody compliant, right? That's really their goal. And they give you notice and an opportunity to cure. That's what they're, supposed to do. But to sort of relate it to this concept, a lot of the privacy policies, the comprehensive privacy privacy laws now have provisions about make them simple, right? Make them readable, right? Lawyers are not good at this, right? We write things in certain ways. We like a lot of words because we want to make sure every word is covered, every verb, every adjective, right? And so in the CPRA and in some other statutes says they shall be readable. They're easy to read. They use language like that. What's my point? If you're bolting in your terms and conditions, which, by the way, that's not the requirement there, although actually Senator Cassidy had a bill pending last year to sort of simplify terms and conditions on the web, but that didn't go anywhere. So if you tried, if you tried to develop a nice, clear, easy-to-read privacy policy, and then you bolted in your terms and conditions, that sort of like defeats the purpose in my view, right? Because terms and conditions are never simple, easy to read, although some are, but generally, they're not. And so, so those are that may be the violation, right? If you do that. But my point is, privacy policies they are unique animals. And think about why you're doing it, why the law requires you to do it, and maybe think about, do I want to do more than that? And maybe for competitive reasons, you want to put more in your privacy policy. Okay, then someone is making a business decision on that. But from more of a compliance standpoint, it's like there are just certain things you need to do, and think about why you're doing any more than that, right? So, yep.
So for making our policies very simple, very readable, not saying more that needs to be said, so we're keeping it very general and vague, is that kind of setting us up? Is it going to come around and bite us?
Yeah, so it's a fact, not in evidence, as I would say, right? Your last qualifier, keeping it general and vague, may not be how I would frame the question. I know that's your question, but keeping it simple does not mean you can be vague. You need to talk about certain categories of information. At least, if we're talking about California or GDPR, right? You have to say which categories. You have to say what your purpose is, right? Some cases like California and the GDPR, you have to say how long you're retaining it, right? And so you can't be, vague, what the purpose, about some of that, right? So it is a balancing act. I'm not saying this is easy, okay? Don't shoot the messenger, right? But I'm not saying this is easy to do. But that's a great question, right? That's a great question. And I'll tell you, the New York statute that's pending now that I referenced this morning, it has a provision in it that says, thou shalt make your privacy policy readable at an 8th grade level. That's what it says. And I'm thinking, really? So you give me this long, I won't say complicated, but very detailed statute, because it has all these definitions, right? That's how legislation is written. A bunch of definitions that are very, very detailed, and then a sentence or two that says, thou shalt do A, B, C because of E, D, and E, and all those are defined terms. And you have to go look them up to try to figure out what all that meant. And now they're saying, well, we couldn't do it. We couldn't make it at an 8th grade level when we passed the legislation, but by the way, when you put it out there to everybody, dumb it down. Now, I don't know if that'll get enacted, but I will say that's the trend, right, is to make the privacy, and a lot of privacy policies are much easier to read today than they used to be, But some of that is because you're mandated now, to do so. But I'm not saying it's easy.
And I apologize, I guess I wasn't clear. I know that when lawyers, when you're writing things up, you put every little word in there so that there is zero chance of misinterpretation. And when you simplify things, there is the chance of misinterpretation. That's what I'm concerned about.
Yes. And I don't know how to satisfy your concerns, right? It's hard. That's why I'm doing the work. It's like, this is not an easy thing to do. And you really have to have engagement in your organization by a lot of different folks. And a lot of people are like, just go copy the other guy's privacy policy. He's our competitor. He must have done it right. I'm sure it's great. Post it. Change the name, post it. Okay. So I'm not saying, okay, I'm endorsing that. I'm just saying, that's what happens in an organization, right? So you have to name the control, or there may be other definitions, but what's the control, sort of in the GDPR sense? That's who owns the website and collecting. It's not it's not AWS which is running. You have some kind of service with them to run your website, right? It's whoever's collecting the information, in control of the information, not the service provider, right? Not the processor in the GDPR sense. So you have to name who is the person that's really responsible for this. That has to be in your privacy policy. Yep.
Have you had any experience with layered notices?
What kind of notice?
Layered notices?
The log things?
Well, where you would have a simplified policy and then a link to a more comprehensive policy.
Oh, that called a layered? Oh, okay. What's that acronym? What does that mean?
Layered.
Oh, layered. Oh, okay. Yes. I actually think those are that's a great technique, I think, where you have a subject, right, and you say a little bit, and then that's what you're saying, then you link on that, and it drops down with more detail. I think that's a great way to go. I think it's a good way to balance, kind of back to the question here. It's particularly useful for cookies, because when you're trying to talk about cookies, there is a wide spectrum of how much detail you're going to give on cookies. I have seen some cookie policies where they actually list the reference to the code, and this does this, and very, very detailed. You have others who say, well, we've got persistent cookies, we've got the session cookies, and this is what those things do. And others just say we use cookies. But that technique of layered, you say, here's what we do generally with our cookies. If you want to know more, and you click, and then they say we use persistent and session, and blah blah. And then you can click on that if you want, and go to some appendix which has very deep dive, information. Does that answer your question? Yeah, that's a great question. Which all assumes that you've got you've collected the information from your organization to do that, right? Okay. All right, so, and I mentioned this in the session this morning as to what this is just the CPRA, but the GDPR looks somewhat similar. So in your privacy policy, at least if you're operating for California compliance purposes, right, you need to tell the person who's reading the privacy policy their rights under California law. So you need to say, to know what is collected, the right to access, to know what is sold, shared, or disclosed for a business purpose, to delete, to correction, limit, you have to tell the person in your privacy, you have these rights. And, you might not just say that, you have a couple sentences of it that you can describe, what that is. Well, I'll talk about that when we get down there. So in addition to morphing your organization and your systems to be able to do these things, right, operationally, when you get the request to do these things, you also have to be proactively putting it in your privacy policy, in the first instance. If you think you need to comply, with California, right, under the CPRA. I'm not talking about the online, right, the 2004 statute. I'm talking about the new statute that just went into effect. Well, the CCPA had the same thing went into effect a couple years ago, but the CPRA is effective this year. So that's the statute, the comprehensive data privacy statute is what I'm talking about, not just the online one. Question? Great question. Right. So if, right. Yeah, I think the question was, is there a reason to have a privacy policy if you're not doing business in any of these states? Was that, it was a little different, but I think that's what, right, okay, close enough, all right. So, because of the original law, I call it that, right, from 2004 in California, which says if a California resident ends up on your website, you better make sure you have a privacy policy. Even though you're not doing business with them, right? They're just surfing around, right? Whatever. Then you need to have a privacy policy or you risk the violation under California law. Now, maybe that's a business decision you make. Like, well, I'm so little, they're not going to chase me. I'm not telling you to do that. I'm just saying people make business decisions about risks all the time, right? Legal risks, operational risks, insurance risks, whatever it is. So, but by California law, you're supposed to have a privacy policy. So the only way you can get around that is to have some kind of, I call it mechanical controls, right? Some kind of means to stop a California resident from ever getting to your website. And I'm not sure how you'd really do that, right? And ensure that anyway. I'm not saying there aren't ways to geo-block, but I'm not sure you can be 100% on that. So the answer to the question is, if you think a California resident's going to get to your website, you're supposed to have a privacy policy. But not with all these things, right? Because this is the new privacy law, that's a $25 million threshold or the 100,000, of California residents annually. So if you don't meet that, well, then you're not into the CPRA, and you can just drop back to the 2004 as amended by the 2013 law. Yep. Could you speak just a little louder? Okay. Usually we have a mic in here. I don't know where the mic. A consumer's privacy expectation. Yes. Right. Right. So business issues, legal issues, compliance, right? Kind of two different things, right? As I said earlier, you may choose to disclose certain things about what you do and what rights you're giving to that person, regardless of what the law compels you to do. And maybe you're not compelled to do it. Maybe you do that because you believe, as I think you're suggesting, some individuals today expect that, and maybe for competitive reasons or other reasons, you want that. You don't want to be shamed in some social media about not having a privacy policy. And I'm making that up. I don't know what it would be, right? So yeah, those are business decisions you can make to do more than what the law side, the compliance side, tells you to do, right? So you got to listen to your lawyers, you got to listen to your risk managers, you got to listen to your business people, and someone makes a decision about it. I guess the other way to look at it is sort of the arc of time, right? I think there were a lot less. I mean, privacy policies started getting posted back in the early 2000s, but I mean, I'm not really sure. I don't know how many people cared about it, how much it impacted the business, right? It may be a different factor today, and it may be a generational thing too, a cultural thing that's moved over time. That's like above my pay grade to answer all those questions. I don't know, right? So, yep.
So even B2B companies, you mentioned that before.
Right. Yeah.
What we did find was, I can't remember if it was GDPR or CPRA, it applies to consumers, which also includes job seekers.
Yep.
So we basically built our privacy policy around our job seekers and how we track them. I wanted to point that out, but that's important for all B2B companies. Most of us all have.
So let me see if I can translate that. You're business to business, and you're thinking most of the individual data I'm getting is from someone who wants to apply for a job here. That's like the 80-20 rule, right? Like I need to deal with that because everybody else who's coming to my website is a business, and you're thinking, well, I don't need to worry about that, but now at least California GDPR, you do. So you built it to say if you're, so yeah, I appreciate, that's a great, back to the question back there, right? That's a great business decision, is how are you going to deal with this, right? Other people have just said, if you're seeking a job applicant, this is not your privacy policy, link here or call the office or, whatever you do. So, but that I understand that's a smart business decision to say, I'm going to deal with that because that's most of it, right?
Just a mechanical question. The 25 million gross revenue threshold, is that worldwide, or is it 25 million of gross revenue derived from California revenue?
No, it's top line revenue anywhere, right? And there's actually, there's actually a definition that might sweep in affiliates or people who are under the same brand, kind of like beyond what I talk about today. So, if you're in a corporate structure, you got affiliates, sister companies, or whatever. Don't necessarily think, oh, that's not in the 25 million. It might be. Answer your question? Okay. And that's the CPRA, right? So you're talking about the annual. Right. Okay. So, 6 minutes. Okay. Well, so do not sell. I'll just talk about that a little bit. Right. So the CPRA requires that you, just like they had required, years ago to put the privacy link, that you put a link where the California resident can easily say, do not sell my personal information. And you're required to place that on your home page, although, and again, conspicuous and all that, do not sell or share my personal information. Again, sell and share are very broad. And there's another one, limit the use of my sensitive personal information. So all I can tell you is you can just go read the statute. It sort of just lays out like what you're supposed to be doing, where you're supposed to put it, and what some of the other alternatives are as to where you can put it. And you're supposed to put it in your privacy policy, as well. All right, so right, so, and there is nothing magical about these headings, right? These are just the ways you often see it, but there are other ways. And companies are very different in the kinds of information they collect and how they collect it. So one size doesn't fit all, but here are some general things, just to think about. Like, what information are you collecting? And that is required under that, original law, the California Online Privacy Act. How we collect your information, right? That's more the CPRA and the GDPR, like, oh, I collect it I'm tracking you, I'm collecting it from the emails, I'm collecting it on your IP address, right? Because, or are you getting it from, you're getting third-party services that are providing you the information. You're buying, customer lists, sort of in the old concept. Or you're getting it from, your Facebook or LinkedIn or your Google, advertising products that you subscribe to. So, and then you have to say how you're using it, right? That's kind of like the purpose thing. Like, why are you collecting it? What's the use? Because certainly in the GDPR, collecting data for this purpose doesn't mean you can use it for any purpose. Ask Google about that. They got a hefty fine years ago for that. How we share the information we collect. Well, that kind of even goes back to the original act. And by the way, even though I put here in the cyan, that's the California, it's also a requirement under the CPRA, right? But I was trying to say, like, here's the base, these ones I've marked in cyan, like, these are the things you at least have to do to comply with that Online Privacy Act, but you also have to do those things to comply with the new act. But the rest of these are things that come about because of the new statute. So how we retain, right? So, the GDPR concept is both data minimization, like only collect what you really have to collect. And then how long do you need it? Right? Those are related but different concepts. And you know, most of the products, like a CRM product, will have a way to eventually say, okay, that's stale, delete it, you know, make it go away, you know, which is a good thing to do. I mean, we were talking about cyber insurance before. A lot of people were saying, you know, I know this is a pain to try to figure out, only collect what you need, minimize what you collect, and put some retention, you know, put some fuses on it so it goes away at some point. But, you know, for insurance purposes, it's like the less that you have to deal with, the less your exposure. I mean, that's not like rocket science, right? Less data. If I'm shrinking my data set, well, maybe I got less exposure, right? Just that sort of general concept. Cookies. How much time? Oh, it's on there, yeah. Okay. Cookies, well, we talked about cookies a minute ago, right? So, you know, describing that, there's all sorts of approaches to that. Google Analytics. So almost every website has Google Analytics on it. I mean, if maybe yours does, I don't know. But it's a free product, free service, right, from Google. Why? Because Google gets to collect all this information about what's going on all across, you know, the web. And so, and what do you get for that? Well, you get a dashboard of some statistics, like how many hits do you get? When are you getting the hits, right? You know, you get all kind of helpful information when you're trying to market your products or your services, but it comes back pretty much anonymized, right? You don't know who came to your web under this product, right? I mean, Google and Facebook, and they have those other products for the advertising. But the basic Google Analytics is just, I just want to understand who, in general, who's coming to my website. And you can get some location information, like maybe by zip code. You can get, you know, some other demographic information, but you can't identify, you know, or not supposed to be able to at least identify any particular individual. So it's very, very helpful. And I say here, not only does the CPRA, GDPR, but Google requires that you put a certain clause or a certain concept into your privacy policy that says, you know, Google Analytics is being used, and if you want to see Google's privacy policy where you can opt out of certain things, here's a link, go to Google and, you know, adjust your profile. So contractually, if you're using Google Analytics, you're supposed to have this part in your privacy policy. And then how we notify you and the effective date. So I'm out of time, always. Let me just do this. The selling, this is the definition in the CPRA. See, I keep saying how broad it is. Selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating. That's sort of a distorted way of talking about a sale, right? But that's the definition. So it's very, very broad, because they're saying, well, I know you're not, what they're really trying to get at is, I know you're not getting paid by Facebook for that, but there's a value proposition. You know, there's some, you know, deal, there's some bargain there, because even though you're not getting money, you're getting something back, and that's kind of what they're saying. Well, that's a sale. They're basically saying any of those things where you get a benefit, that's some kind of, that's the concept on it. Okay, well, I'm out of time. Yeah, I'm out of time. Yep.
Can you put the email address back up?
Oh, sure. I think I can. This is not my computer. I don't like it. There it is. That's Bridget's email, and if you want, you can have it printed out. Yep. All right, and I'm happy to talk, but we have a break now, so, and then have a 15-minute break. Please enjoy yourself with whatever refreshments are out there, and we'll be back in this room for a panel discussion, a view from the trenches with our three panelists. So, thank you for your attention.